Evans, 12. Carter, 4. Chairman, we have 4.
All right, I'll call it to order. I don't know if this is on or not, but thank you. Okay. All right, thank y'all. We'll, if you'll bear with me, I'm going to kind of jump around on the agenda. We have a number of bills here to take up. So, okay, so first we'll call up House Bill number 87, second on the agenda. And you have a proposed, what you have is the strike all, and the strike all has a reverse repealer in it. That's the only difference between the proposed strike all and the bill. This is requested from the Department of Human Services to give their investigators law enforcement powers. I will tell the committee that I have had conversations with the director as well as Commissioner Tyndall about law enforcement. There are ongoing conversations to address this. There are, to be quite honest, there's good arguments on both sides for making them under DPS or for making them under DHS. So there's a reverse repealer to keep this going and to allow for more conversation on that. So I'd be happy to answer any questions on that. If not, I would entertain a motion.
Just
a question.
now,
Yeah.
It's really more of a statement. I have real concerns about this. It looks like the direction that we're kind of headed just with law enforcement in general in the state. We've taken Capitol Police, we're putting them with DPS. We need to have an overall conversation. Are we going to look more like a state police in Louisiana? Like, where are we going with all of these things? And that's a very good organized system. So, you know, I'm glad for moving this along, but I feel like, and I feel certain you are as chairman because you're looking at all this, but I really feel like there needs to be a whole conversation of what we want to do with all these investigators in these different agencies and the standards that we're wanting to look, you know, to look for them to have. And is that in each individual agency, or is there one coordinating kind of criminal investigation unit? That's
So
just
you
my
may
concerns.
have had a bug listening to our conversation. So that is what, not maybe in those terms, but was discussed. And that is, and from the DHS's standpoint, this is how it was put to me. If they had what they're arguing for in this bill, they could have called John Davis before we found out in OIG. Okay. The other side of it is just what you said, and those conversations are ongoing. I think you're correct. That's why I put a reverse repealer in this, because I was not comfortable in calling this up as is, because I think of those conversations. So, and I would encourage, by the way, Senator Boyd, I would encourage you to speak with both Bob Anderson and Commissioner Tyndall, because they're both doing a good job for their agencies. And I think, but what you're hitting on is some of the things that we talked about.
Okay.
So anybody can talk with.
All right, thank you.
So do I have a motion? Motion is title sufficient, do pass. Strike all. All in favor, say aye.
Aye.
All opposed? Ayes have it. Thank you. Okay, going to, I wanted to go to, because this is double referred, House Bill number 695. This is, we passed, this is a strike all that has the bill we passed in it. This is Chairwoman Cockerham's bill. And if you remember from that bill, it was removing the matching funds requirement and allowing for the domestic violence fund to be funded on that. So that's the explanation of the bill. Is there any questions? Motion is title sufficient to pass. All in favor, say aye. Sorry, strike all. Thank you. Oh, no. Let the record reflect that freshman England caused problems with that one.
I believe it was explained as a strike all to enter.
Let the record reflect that Chairman Wiggins didn't mess up. Just kidding. All right. Next, we'll go to House Bill number 341. I'm sorry. I called for the vote on the title sufficient to pass motion. Thank you. We'll call up House Bill number 341, motor carrier safety improvements. And I'm going to turn that over to Chairwoman Brandon for that.
Thank you. This is a bill you all have seen before. It's a companion bill to what we had is Senate Bill 2478. The intent is to put motor carriers in a position to offer more safety equipment and options to independent contractors without a misclassification to employee status. And you'll see that in section 1, this is all new language. And the last, I guess, phrase of this, starting in line 13, shall not be considered in the evaluation of an individual status as an employee, independent contractor, or jointly employed employee under state law. So that's the new language. And then if you refer to section, beginning on lines 88, it further defines what we mean by motor carrier safety equipment. Oh, I am looking at the Senate bill. I apologize to the committee. Just a minute. So the line
Pass, all in favor, say aye.
Aye.
Opposed? Motion carries. Okay, next I'd like to go down to the last House Bill number 1195. This is the companion bill to the one that we passed, the electric bicycles that are needed. Oh, thank you. That was Senator Whaley's companion bill. And again, I'll be in touch with the chair lady over there. I think actually our bill went to a different committee from Judiciary A over there. And so want to keep this going. But this is the same bill that we had, that we passed, and Senator Whaley presented on that. So if there's any questions, I'd be open to those. Motion is title sufficient to pass. All in favor, say aye. All opposed? That one carries. That motion carries. Next, all right, I'd like to go to House Bill number 356 and call that up. This came over, this is a bill, you have a proposed strike all in front of you, and this bill going to the first, in let's see, section 1, Section 1 is the language that came over from the House. I'm sorry, Section 1 down to, I think, subsection 2 is the language that came over from the House. This is requested by the CPS as well as the governor's office, and it's the language will bring us in line with the federal side of things, and then also beyond that is the same bill that we passed on the child advocacy centers, granting immunity to the child advocacy centers. And so actually, if you look at section 1, district attorneys, DHS, child protection services, let's see, hold on, I apologize. Well, we need a copy. I'm sorry, we need a copy. If we can get a copy of House Bill 356. Okay, the explanation. Huh? Oh, thank you very much. Okay. All right, so that explains it. I apologize for that. So section 1 is the bill from the House that the governor's office, CPS, wants, and to keep us in line with the federal law or federal authorities. And then the proposed strike all that you have is the law that we passed on the on the CACs. And so what the intent was that all of that would be inserted as the strike all. So y'all, okay, thank you. The strike all would be section 2. Does anybody have any questions on that? Sorry for the confusion. We're trying to get that. Okay. Do I have a motion? Motion is title sufficient, do pass, strike all. All in favor say aye. All opposed? The motion carries. Okay, I want to call up House Bill number 3. This is the outdoor advertisement. So here's and many of you may have been spoken to. My understanding about this bill is that there has been a lot of discussion between MDOT and billboard carriers back in, I think it was about 10 or 11 years ago, after Hurricane Katrina, when Billy Hughes was here in the legislature, put into law dealing with billboards that affected down on the coast. Okay. So then there was some litigation that's gone on and made lawyers nice and, well, I don't know about rich, but they made them some money. And then this bill, it came over from the House, is supposed to address the language and cover what is in the discrepancy with MDOT and with the billboard providers. Let's see. So if you look at number 2 under section 1, signs erected prior to July 1st of 03, and it lists the size and the square feet of them. And then you go down to C, it says, except with respect to any sign or structure before April 15, 2018 that is converted to digital, said sign shall be considered a conforming structure provided that they are not modified to exceed their permitted height. My understanding is that much of this discussion is over the digital signs. And if you look at line 72, it says none of the provisions of this section shall be construed to allow any sign structure over 40 feet to be converted to digital unless the sign structure was lawfully converted. Now, I've been told that the bill corrects this, but I've also heard from other members. So with that, I'm putting it for the committee for discussion and anything. So do I have any questions on the bill? Senator Turner Ford.
Thank you, Mr. Chairman. I'm just not sure I understand what the problem is.
And I'm looking for it. The problem is just what I said, that there is a dispute between MDOT and billboard sign owners about the height of the billboards and whether they can go to it, whether what their height can be in digital signs since after Hurricane Katrina. And I will not bore you with the legalese, but apparently it's gone through the courts, and and there's a discrepancy of what this means. Right, there's a discrepancy of what some of the language that was amended back after Hurricane Katrina. So that's the I'd asked the sponsor to be here, but I don't see them. So I think that's what we're trying to do now. I think looking at it, the language speaks for itself. On the bill.
Is the issue that some of these signs are tall and
Yes. Senator Boyd.
Just from what I understand and being approached by a number of different people on this piece of legislation, we have numerous sign companies within the state. We have one sign company that really loves this legislation, and then we have other sign companies who do not like this legislation at all. I've heard also too from various partners that MDOT may have some concerns about the legislation, and it doesn't seem like we've fleshed through all the issues to date at this point in this legislation. So at the proper time, I'd like to make a motion at the proper time.
Okay. I'm sorry. I didn't realize. I have invited former Representative Baker. He may enter any moment now. And I was going to have the committee listen to him because here he is. Come on in, Mark. Mark, we've taken up, you were probably, oh, good Lord. Thank you. So, yeah. Okay, so Representative Baker. So we've called up the bill for the House Bill number 3, and you're welcome to briefly explain the bill, because we've had a question from a couple of the members, particularly Senator Turner Ford, about why this is needed and what it's for.
Thank you. Mr. Chairman, your explanation was generally on point. I was following it outside. And so in 2008, then Senator Pro Tem Billy Hughes and the Iowa Raptors got together to resolve some issues with regard to billboard signs, like billboard signs. And what happened was that language that was intended to be in then 2955, which was a bill that was passed in 2008, was inadvertently omitted. And we know that because Senator now Mayor Hughes added in the litigation that ensued, that you heard about, filed an affidavit and said, this is what I intended. And in fact, if you look at 2955 as introduced, the language of the sentence that said that everything before 2008 good, everything after 2008 subject to height limitation was not in the bill. The federal district court even acknowledged that, and the Fifth Circuit acknowledged that as well. So from approximately 2014-15 till kind of now, there's been an effort to resolve this conflict. And how it came about was there was a 90-foot sign on the coast that Lamar on the district actually wanted to reduce the sign down to 70 feet. And MDOT said, no, you can't reduce the sign down to 70 feet because that's a non-conforming grandfather sign, so you got to leave it at 90 feet.
And I think that's a good word, non-conforming. The issue over this has been non-conforming signs. Is that right?
Right. Why does that matter? Because if you're in an area where if your sign is a non-conforming sign, sliding on the city attorney, if you have a non-conforming sign, then you put that sign back up. If it's slowed down by a hurricane, if there's more than X% damage to the sign, you can't put it back up. Okay? And so where this matters in particular is to the sign stock that is down on the coast. Now, there are other signs that are over 40 feet, but those signs are not in a hurricane alley where the entire skyline gets wiped down. Hence, in 2008, after the issue with Katrina resolved, they came back and tried to get this issue cleared up, so we knew that the sign stock, something most of which dates back to when gaming became legal, was in effect. And so that was the intent of that particular statute in 2008. Did get put in litigation ensued from that point till now. We've been in some form or fashion to try to clear that up. In fact, the Fifth Circuit Court of Appeals even said, there's a summary of opinion that came out in 2020, says the parties continued discussions from 2015 to 17, but no resolution occurred. The MTC, Mississippi Transportation Commission, asserts that Lamar and the MTC joined forces to get a legislative revision. So MTC took the position that MTC and Lamar worked to get a legislative revision. So in fact, that attempt was done last session. It was done one time when I was in the legislature, didn't wear a long hat, and then it was attempted last session, and the language was actually put in last session that you see here. That's Mississippi Transportation Commission language that came out of the House. This is the same bill that passed out of the Senate, came out of the House last year, House Bill 772, and so the language was just.
Mark, let me ask you. So I've heard that one of the other senators has brought up that has said that this language is not it's concerned for what we call the smaller billboards, and that this is not addressing that issue. But are you saying that this is addressing the issue that's being faced by these folks?
Anybody that's got a sign structure that predates 2008, it would help them as well, because that's where, anything before 2008, if you read the language, would say you're illegal to go on the sign. So whatever your sign stock would be, okay? In particular, the problem though occurs with regard to the sign stock because if you look at the sign at one point, you don't have a hurricane issue. Otherwise, you say, but it would affect anybody that has sign stock.
Okay.
Because the signs it up.
Okay, I want to turn it over to the committee for questions. I know Senator Barnett has a question. Mark, go ahead.
Thank you, Mr. Chairman. We've had several pieces of legislation this year that has came through various committees where there has been an agreement reached between all sides or all parties involved so that we can keep the legislation moving forward. So why is it that we are trying to pass this piece of legislation when MDOT is not in agreement with this, or we haven't heard anything from them as to where there has been a compromise or an agreement reached to where we could pass this? So if we're going to do this, Chairman, I would just ask that individuals from MDOT shouldn't have had an opportunity as well to explain to this committee their opposition to this, or there should have been a notification that all parties had reached an agreement, and I'm not hearing that with this piece of.
Well, I think your point's well taken, but let me say this. This bill was sent to us by the House, and sorry, pardon my language, but ain't nobody from MDOT come over and talk to me about it. And I've had other people, including senators, talk to me about it, and MDOT hadn't chosen to come here and ask and talk about it. And let me say about the lawsuit, from what I understand about it, is the lawsuit got removed to federal court by MDOT. And guess what? The Fifth Circuit sent it back to state court. So MDOT on that situation has caused a lot of attorney's fees and other things to have gone on. So I certainly think that it's within this committee. I brought it up for discussion. You're right. We have let things to keep discussion going. But I wanted the committee to hear this. But as far as MDOT coming and us waiting on that, this bill's been pending since the beginning of session, and I haven't heard from any of them. So from that, but I've heard from individual senators and I've heard from a few House members. So, they haven't been here. Senator England.
Yeah, thank you, Mr. Chairman. I have a question on, so lines 27 through 30, that's appears to be the main part of this this bill and the changes that are being made. And if I'm reading correctly, at the end of 28, it said signs shall be considered a conforming structure as long as they don't go beyond their permitted height. But are there other requirements to be a conforming structure that we're deleting? So we're only looking at height now, and we're not looking at other restrictions that may be in place, because we're just now based just solely on height. We're determining that we have conforming structures. And I don't know if it doesn't say conforming as to height, it just says conforming structures. So are we, is there a lot that's being left out there that we're,
I don't,
kind of getting caught up
I
in the
don't know,
mix
but
here?
if Mr. Baker can answer that.
Those signs would not be there, because they wouldn't be permitted by MDOT if they didn't meet the other conforming requirements. And they would lose their permit, for example, they should be 672 square feet. Everything that is immediately preceding that is part of the permitted process. And so they never would have got permitted in the first place, and that's not a grandfathered issue. That's something that you have to maintain. For example, the locational requirement, 600 feet, and things like that, that are other places. Those are requirements that continue forever, regardless.
Well, see, it seems like there's something that's left out there that we could address this concern at the end there of that sentence. Because right now we're just saying they're conforming structure provided that they are not modified to exceed the permitted height. So the example you give, a 90-foot sign, it wants to come down to a 70-foot sign, that would meet that. But there's nothing here that also says to be a conforming structure, it also has to meet the other requirements. And I'm worried that we might drop a 90-foot sign down to 70-foot, and because it didn't exceed 90 foot, there are other changes that could be made to that sign, and it still maintains under the language as I'm reading it, it would be a conforming structure.
But that, understand, that's the only thing we're working on conformity of. Everything else is in statute. These are other requirements. Height is not the only requirement of a sign. It's location, it's face size, everything like that is a requirement. Those are in the law. You can't have a permit regardless. You can lose a permit if those things don't exist.
Are there other, I know we have one big company in Mississippi that does this. Are you aware of any other sign companies that are in favor of this other than the one largest company, that being Lamar?
I've not heard any of the members of their non-professional organization.
Okay.
Okay, any questions? Senator DeBar.
Thank you, Mr. Chairman. So, there's pending litigation on this matter now, is that?
Yes,
correct?
Yes, it's gone through the courts, and based on what's been provided is the courts have said y'all need to go find a legislative solution.
So the courts have directed the legislature to resolve something.
Yeah,
they
and as Mr.
can or
Baker,
won't do. Yes.
as pretty much, and as Mr. Baker said, they tried it last year and it didn't make it through. So,
And this is the language that MTC and the companies have agreed on? Or suggested?
based on the bill coming over here and what I've heard, apparently there isn't an agreement yet
You've heard
on
no
this language.
opposition from MDOT at this point?
I represent to this committee that nobody from MDOT has contacted me about
Thank you,
this.
Mr. Chairman.
Senator Kirby? Okay,
Senator Turner Ford is.
okay. I think Senator Branning, you had a motion.
Question.
Oh, I'm sorry.
Thank you, Mr. Chairman. Based on the example that was given of a sign being reduced from one height to another, how can that be designed on this image and line, what is paragraph?
Well, the sign, the statute is amended, and the sign predates 2008. And the sign postdates 2008. It won't be a certain height. So because, and if you read the current law, you have a sentence about height, and then you have another sentence about height, and as Senator, now Mayor, you said, first sentence wasn't supposed to be there. And so if you're saying that forever and all time, the sign is 40 feet, it's basically declare every sign that's in Mississippi over 40 feet to be a non-conforming sign. And so, NDOT's position, as any government's position, is if you have a non-conforming sign, you can't alter the height of the sign or you'll lose that sign. And so that's how the bus kind of started. They tried to lower the sign. And the position was, no, that's it. You got an extra sign, that's all you can have. Now, I agree with you. It seems to make sense that the position should have been to bring it lower, that ought to be okay. But that wasn't. And so ultimately, off to the courts, everybody went. And so then we got batteries for everyone.
And if I can sum up my understanding of Mayor Hughes drafted the original legislation when he was here. It was there, and then when the lawsuit happened, he did an affidavit saying this is what I meant when I drafted it and what it was. But apparently the court didn't. They said what was written didn't accept it, and so the author is saying this is what it meant, and the court is saying no, it's not, or at least that's not how it's written, and that's why we're here. Senator Barrett, do you have a question?
No, Mr. Chair.
Okay. So any other questions? Senator Boyd.
Are we sure that this language conforms with the federal code? Because I've been presented information that this is non-conforming language with the federal code. So have we done our due diligence to make sure that this is conforming language with the federal codes on this?
I don't know that answer.
Okay, thank you.
Okay. Senator Branning, you had a motion.
I think after the discussion, we all agree that there's still maybe some unanswered questions and some more work that could be done on the bill. So my motion is that we add a reverse repealer to keep it moving, to give those proponents the opportunity to keep working your questions, to be able to still put forward, and we can sort of move it along. So that is my motion, to add a reverse repealer.
Okay. Senator Barnett, if you had a question on the motion.
Yes. Well, I would like to have a motion in the proper time.
Okay, well, we have the motion before us on the table, which is a reverse repealer. So call for a vote on that. All in favor of the reverse repealer, say aye.
Aye.
All opposed, motion carries. Okay, Senator Barnett.
Yes, sir. I would like to motion that we table this thing.
Okay, you are allowed to speak on your motion.
The reason why I asked that we table this bill is Senator Brandon kind of hit on this, that there are just so many things that's not clear in this. Senator Boyd also, in her statement, that we haven't gotten the information that says that we are meeting federal guidelines on this. And also, in respect to MDOT, I know that you have said that they haven't came and talked to you about it, but I would ask that, like we have asked so many of us to move forward, that all of the parties that are involved at least have an opportunity to come and have an agreement to say we are all in favor of this, or here's what the agreement are before we do this. So that's the reason why I asked that we table this.
Okay, well,
And I'd like to ask if there's a vote for it, and if I'm in order that we do a vote by show of hands instead of a voice vote.
sure. We'll call the vote. In response, I would say that I think as amended, we have a reverse repealer in it. And between now and conference, there's this time to get to the bottom of this and work these things out. I mean, it came to us from the House. So I think the reverse repealer certainly has addressed that. I think, and I'll represent to the committee, and Mr. Baker is a good, he's familiar with this process up here, and I think he sees where the issues are, and we can address those in conference. So that would be my response. Anybody else speak on the motion to table? right, on the motion to table, all in favor say aye.
Aye.
All opposed?
No.
The ayes have it. Thank you. All right. Next one. We will call up House Bill number 1077. And this is, many of you know, an open account. And this is, if you're familiar with the open account, there's some questions within the law about notice and all that. So this is attempting to address the notice requirements for open account. And if you look at subsection 1, that defines what an open account means, a series of transactions, so forth and so on. And then if you go down to line 31, to have a demand, and that lists the notice requirements that need to be sent out on an open account. And that's really what it is. I think the problem has been with the open account law is about notice and demand on that, and this is trying to address that. So with that, I'd open it up to any questions.
So the goal, Mr. Chairman, would be.
Senator McCott.
Thank you. Sorry, I apologize there, Mr. Chairman. We just to make this a little bit easier and a little clear, a bit more clear for the consumer that we're looking at here.
Yes.
Trying to make.
Yeah. The answer is yes.
Yes.
Any other questions? Do I have a motion? Motion is title sufficient, do pass. All in favor say aye. All opposed? Okay, that carries. Then last one, House Bill number 1012, charitable solicitation. This comes to us from Chairwoman Cockerham. And we had a similar bill in the Senate, which is providing notice on where there's charities involved. And my recollection is this was also required or requested by the Secretary of State's office. And the language that is being addressed is in section 2, which is at line 186. A charitable organization, person, professional fundraiser that solicits contribution to the state shall be subject to notice or demand as provided in the section. When we did the Senate bill, had spoken with the director, I guess, in the Secretary of State's office, who said there were these charitable organizations getting around the notice requirements and therefore not abiding by the laws, and this is trying to streamline that and capture those. So the optimum language is there in section 2 of the bill. That anybody soliciting funds needs to provide this, and as the Secretary of State said, people are soliciting funds and they're not registering as a charitable entity. So this is trying to address that. Any questions, or open it up to questions? I'm sorry? Senator Blackman.
Yeah, no, it follows this bill, so but the open account does.
Okay, sin is going to be subject to a notice of demand. So what is provided in this particular section? So what is the Secretary of State going to be doing? Just trying to tell them they need to register?
That's essentially it. That there are people soliciting for donations that under the Secretary of State's office or should be registered as charitable organizations and have not done that. And this is clarifying that anybody seeking those needs to register accordingly.
Is there a penalty if they do not?
Yes, let's see. Somewhere it was earlier in the bill.
Previous legislation.
Yeah,
Okay, thank you. Chair.
thank you. Okay. Oh, I was just informed that on line 192, 793513 is the UCC for entities, charities, right? Entities, which has that penalty. Yes, Senator McCall.
Thank you, Mr. Chairman. I do have a question on it. With this, is there an exception in here for like, your local sports, kids raising money? Is there some type of exception for that in there? I'm just thinking, everybody's got kids out there that raise money for their sports team or what have you. Would that apply? Would this apply to that?
If you go look at starting at line 20, where it defines charitable organization, and it goes in and talks about that, I would hope that, I guess, just your Girl Scouts and all that wouldn't be tracked down by the Secretary of State and doing all that. So I think it would fit with the definitions that are in here. So I think that would answer your question.
Thank you, Mr. Chairman.
And I don't think the Secretary of State would want to go out, at least I don't think it'd be good to go out and try to hound those people.
Well, I would think it would be an overwhelming burden on them
Correct.
if they were having everybody to come in and try to apply. So just trying to balance that out.
That's right. Okay, any other questions? Do I have a motion? Motion is title sufficient to pass. All in favor say aye. All opposed? Motion carries. Okay, thank you. Do I have a motion, rise and report? All in favor say aye. Opposed? Rise and report. Thank you. Appreciate it.
How many you need? One?
Yeah.